Now I am going to dictate a latest Supreme Court judgment passage for upcoming Jharkhand High Court examination or any other court's examination at the rate of 120 words per minute. Let's start. We have heard learned counsel on both sides. The facts in appeal arising out of SLP within brackets C number 16342/96 are sufficient for disposal of the common controversy raised in these cases. This appeal by special leave arises from the judgment of the division bench of the Andhra Pradesh High Court made on June 18, 1996 in W.P. number 612 of 1996. The appellants had initiated disciplinary proceedings against the respondent on the imputation that on September 15, 1995, while driving the corporation's double-decker vehicle near Gandhi Hospital in Hyderabad city due to lack of anticipation, he had caused an accident in which a cyclist died. Consequently, action was initiated for misconduct and inquiry was ordered for misconduct under regulation 28 within bracket 9 of the Employees Conduct Rules 1963. It would appear that the prosecution has been launched by the police for an offence punishable under section 304 part 2 IPC and in some cases under section 338 IPC, and they are pending trial. Therefore, the respondents filed writ petition in the High Court for stay of the departmental proceedings. The learned single judge stayed the proceedings on appeal. The division bench confirmed the same. Thus, these appeals by special leave para. It is contended by Sri Altaf Ahmed, the learned additional solicitor general appearing for the appellants, that the High Court was not right in directing stay of the departmental inquiry on the ground that is would cause prejudice to the respondents at the trial. In the criminal case, the question is the culpability of rash and negligent driving of the respondent in the departmental inquiry. The misconduct relates to his failure to anticipate the accident and prevention thereof by his conduct. Therefore, there would be no prejudice in conducting the departmental inquiry. The High Court therefore was not right in staying the proceedings para. In support thereof, learned counsel has placed reliance on the judgment of this court in State of Rajasthan versus B.K. Meena and others within bracket 1996 7 ACALE 363. Sri L.N. Rao, learned counsel for the respondent, on the other hand, has contended that the ratio in the judgment itself would indicate that only in grave cases the inquiry should be permitted to complete it as expeditiously as possible. Otherwise, the administration would be jeopardized. In this case, such a grave nature does not arise. The facts in both the criminal case and the disciplinary inquiry constitute the same cause of action or material disclosure of which would gravely prejudice the defense of the respondent in the criminal case. Therefore, the High Court was right in staying the proceedings. In support thereof, he placed strong reliance on the judgment of this court in Kusheshwar Dubey versus Mrs. Bharat Cooking Coal Limited and others within bracket 1988 for SCC 319. He also placed reliance on the judgment of this court in Food Corporation of India versus George Varghese and another within bracket 1991 sub dot 2 SCC 143. Therein the question was that whether the High Court would be justified in quashing the inquiry proceedings after the acquittal of the delinquent officer in the criminal case. The High Court had held in the case that it was not expedient to conduct inquiry after acquittal while interfering with that view and holding that the employer is entitled to initiate the disciplinary proceedings after the acquittal. This court made an observation that the employer family had stayed its hands till the conclusion of the criminal case show that it would not be contended that the employer intended to overreach the judicial proceedings. That observation, far from helping the respondents, would go to show that it would be open to the employer to take appropriate disciplinary action based upon the fact situation. Whether it could be proceeded with or not would be left to the disciplinary authority, and the facts and circumstances obtainable in case each required to be considered para. The rival contentions give rise to the question whether it would be right to stay the criminal proceedings pending departmental inquiry. This court in Mina's case had elaborately considered entire case law, including Kusheshwar Dubey's case, revealing the necessity to consider them once over. The bench to which one of us, K. Venkataswamy J., was a member, had concluded thus. It would be evident from the above decisions that each of them starts with the indisputable proposition that there is no legal bar for both the proceedings to go on simultaneously, and then say that in certain situations it may not be desirable, advisable, or appropriate to proceed with the disciplinary inquiry when a criminal case is pending on identical charges. The staying of disciplinary proceedings, it is emphasized, is a matter to be determined having regard to the facts and circumstances of a given case, and that no hard and fast rules can be enunciated in that behalf. The only ground suggested in the above decisions as constituting a valid ground for staying the disciplinary proceedings is that the defense of the employee in the criminal case may not be prejudiced. This ground has, however, been hedged in by providing further that this may be done in case of grave nature involving question of fact and law. In our respectful opinion, it means that not only the charges must be grave, but that the case must involve complicated questions of law and fact. Moreover, advisability, desirability, or propriety, as the case may be, has to be determined in each case, taking into consideration all the facts and circumstances of the case. The ground indicated in DCM and Tata Oil Mills is not also an invariable rule. It is only a factor which will go into the cells while judging the advisability or desirability of staying disciplinary proceedings. One of the contending consideration is that the disciplinary inquiry cannot be and should not be delayed unduly. So far as criminal cases are concerned, it is well known that they drag on endless where high officials or persons holding high public officers are involved. They get bogged down on one or the other ground. They hardly even reach a prompt conclusion. That is the reality in spite of repeated advice and admonitions from this court and the High Court. Stop. Thank you. Jai Hind. Jai Mera Bharat.